Good afternoon, everyone. Welcome. I am Dee Baker, and I have the privilege of working at Hospice and Community Care. Thank you for joining us today for our Financial and Estate Planning Seminar, What Do I Do Now?, where we will learn the roles and responsibilities of an agent under a power of attorney or an executor of a will. A few housekeeping items. Everyone will be muted throughout Tom's presentation. We will take questions at the end of his presentation. If you can put in any questions that you have throughout the presentation at the bottom of your screen in the chat box, we will go through those at the end. If you're not able to do that at the end, just simply raise your hand and we'll get your question, then I can unmute you. I'd like to introduce Tom Shorb, today's speaker. Tom is an attorney with the law firm of Stock and Leader in York. He is the chair of the firm's estate practice group and works in the areas of wills, trusts, estate planning, and estate administration. He graduated from Villanova University and Delaware Law School and is a member of the Pennsylvania Bar Association and the York County Bar Association. Tom is a member of Hospice's Planned Giving Council and volunteers for numerous York County organizations. I will turn it over to Tom.
Thank you, Dee. And it's very nice being with everybody today virtually. It's the times that we're living in, but again, it's a pleasure being with all of you. We're going to talk about the role of an agent under a power of attorney, and also the role of an executor or an administrator of an estate. And the information that we're going to be sharing is really general information. And as indicated, you know, the legal issue depends on the particular facts of each case. And Pat, if you could pull up the outline, please, the PowerPoint. And next page would be, and the page after that. So we start with the role of an agent under a power of attorney. And well, what is a power of attorney? It provides for someone to act for you. You know, I have a power of attorney and I have my wife named as my agent. And on the next slide, we provide some definitions. The principal, the person who gives the authority. Agent is the person designated by the principal to act on behalf of the principal. And so in the example I gave, I have a power of attorney. I am the principal. My wife is my agent. She's allowed to do all the matters that are designated in that power of attorney. You often hear the phrase durable power of attorney. Durable simply means that the power of attorney remains effective even when you would be disabled or incapacitated. In reality, of course, that's when we want to make sure that the power of attorney is effective. So when and how long is a power of attorney effective? It is effective only during the principal's lifetime, and it's automatically revoked by death. So, I have a power of attorney. I name my wife as my agent. If she can handle anything that I provide for under that power of attorney during my lifetime. If I pass away, then she would then have authority as executor under my will, which we'll talk about in a little bit. But the important thing to keep in mind is that power of attorney is effective only during lifetime and automatically revoked by death. So what happens if you would be incapacitated and you don't have a power of attorney? Well, say if I'm in an accident where I have a medical condition where I can't do things, well, my wife would be able to handle banking through our joint checking account, no problem at all. But what happens if a deed needs to be signed for the sale of our real estate? What happens if a stock transfer needs to be made for stock that's jointly owned? What happens for a tax matter or an insurance matter? In the absence of a power of attorney, it would be necessary to go into court and have a guardian appointed. That process of having a guardian appointed, one, it's expensive. Secondly, it's time consuming. And thirdly, I think the most difficult thing about it is emotionally draining for a family, because you have to have a petition filed with the court. Every conceivable family member needs to be notified. You have to have a hearing before a judge. You have to have a doctor testify as to the incapacity. And then after you have that guardian appointed, the guardian has to file a written report once a year, every year, as to everything he or she does as guardian. So if you have a power of attorney, in effect, you can eliminate that whole process of a guardianship if a person becomes incapacitated. And in reality, the agent under a power of attorney would have and could have far greater authority than a guardian would ever have. So the types of powers of attorney, one right before that, Pat, financial or healthcare power of attorney. A financial power of attorney would be just that. It's where you give the agent the authority to handle financial matters. A healthcare power of attorney is one where you give the agent the ability to handle healthcare matters. Years ago, it was very common to combine those into one document, a financial and a healthcare power of attorney. Nowadays, in most situations, they're separated. And I think it's far better to have that separation. So in a financial power of attorney, I name an agent and I give my agent the ability to pay bills and handle financial transactions, sell real estate, et cetera. They're the powers most often that are exercised by the agent under the power of attorney. However, by statute, there are what are called special powers, and they are called special powers in the statute. And they would allow an agent to make gifts of your real estate, to change or create rights of survivorship, put property in joint names or take it out of joint names, or to change a beneficiary designation form. And very often those special powers come into play for a couple of reasons. You know, one, gifting, maybe if the principal is incapacitated, gifting can be made to reduce the size of the estate subject to, say, Pennsylvania inheritance tax or federal estate tax. Another situation where these special powers could be needed, say if one spouse has dementia and the other spouse is living in the home and the spouse with the dementia has to go into a nursing home. Well, maybe there's planning, what's called Medicaid planning, that can be done to preserve the assets for the spouse living in the residence. That would be an example where these special powers can become very valuable. You can also put in the power of attorney the ability to allow somebody to request an accounting. And you may wonder, well, why would I do that? You know, an example could be, what if there's 3 children and one of the children is named as agent under the power of attorney? Well, it could be that the principal would say, I want my other 2 children to be able to ask their sibling who is the agent under the power of attorney what they're doing, to account for what they do, not to be able to do the actions of an agent under a power of attorney, but really just to request information. And oftentimes clients like that because it provides for transparency so that the other children, as an example, would know what's being done. So the agent's duties. On the next slide, general role. Once somebody serves as an agent, they have to act in accordance with the principal's reasonable expectation to the extent that they know of them. They have to act in good faith and only within the scope of the authority granted. And then there's other duties. And on the next couple of pages, you know, we elaborate. You know, they have to act loyally for the principal's best interest, not their own. They have to keep the principal's assets separate from theirs. They don't want to create any conflict of interest. They have to, on the next page, we talk about acting with care, competence, and diligence ordinarily exercised by agents in similar circumstances. And they have to keep a record of receipts and disbursements and what they do as agent under the power of attorney. And on the next page, they have to attempt to preserve the principal's estate plan to the extent actually known by the agent. In other words, they have to act with due diligence and carefully. So on the next page, we talk about the acknowledgement executed by an agent. Now, before an agent can act under a power of attorney, they need to sign an acknowledgement saying that, just as stated here, they will act as agent in accordance with this form. And they'll be saying, I'll act in accordance with the principal's reasonable expectations. I'll act in good faith. And I'll act only within the scope of the authority that is granted. And I'll keep a good record as to what I do as agent under the power of attorney. And frankly, a lot of this is common sense, that an agent would, keep good records, act in good faith, act only in accordance with the scope of the authority granted. Once in every long while, you'll read about or hear about somebody abusing a power of attorney. That's why the statute in Pennsylvania requires that acknowledgement be signed by the agent prior to acting as agent under the power of attorney. And that acknowledgement just needs to be signed and dated. Their signature need not be witnessed and it need not be notarized. But if you think about it, it makes sense. So that the agent is in effect acknowledging, I have to, use due care when I act for somebody under a power of attorney, and I have to keep good records as to what I do. Is a copy of the power of attorney effective? Well, except for the purposes of recording, a photocopy is treated the same as an original, and that's right from the statute. A little bit of elaboration on that. So, the only time, typically the only time, there can be other exceptions, that you need an original power of attorney is to record that, say, in the Recorder of Deeds office. So say if I am the agent under a power of attorney for a family member, and that family member is unconscious or otherwise incapable of signing a deed for the sale of their real estate, I can sign that deed for them as agent under the power of attorney, if that power is in the power of attorney, and typically it is, and I can sign that deed conveying the real estate to somebody else. But the deed, of course, needs to be recorded in the Recorder of Deeds office. But you also have to record the power of attorney before you record the deed to show the authority of the agent to sign the deed. So you can only record the original. So that's one reason why an original is needed. Otherwise, typically the way it works with the power of attorney, a client may say, well, now I have this power of attorney for my parent or other family member. How do I handle that? Well, what I suggest is you take that original power of attorney with you to, say, the bank where your parent does their banking and show them the original. And they would want to see the original, typically. And then they would make a copy of it. And they would keep a copy of that power of attorney in their central files. And then you, agent, would be able to go to any branch of the bank and do any banking that needs to be done. So a copy would be provided to the institution, whether it's a bank or whether it's a broker or whoever else it may be. So a copy of the power of attorney is treated the same as an original. The statute, by the way, provides that a copy of that power of attorney would be treated the same as an original. I also put in the power of attorney that a copy would be treated as an original. It's perhaps a little bit overkill, but if somebody goes to, say, a bank, I want them to see that a copy of that would be treated the same as an original. So on the next slide, How do I use that financial power of attorney? And we went through that. And then the legal effect of agent's actions. The actions of an agent pursuant to a power of attorney has really the same effect as the principal. The person who gave you that power of attorney made that transaction him or herself. Next slide. Compensation and reimbursement for expenses. An agent is entitled to compensation, and the language of the statute, as recited there, is the agent shall be entitled to reasonable compensation. It doesn't state what that compensation would be, but it needs to be reasonable compensation. Very often I find, with close family members, they very often do not receive any compensation. They say, I don't need compensation. I just want to see that this is done for my parent or my sibling or my child or whoever else it may be. But they are entitled to it. And reimbursement for expenses. Similarly, an agent would be entitled to reimbursement for actual expenditures made on behalf of the principal. So if an accountant is paid to prepare tax returns, the agent can be reimbursed for that expense. The durable healthcare power of attorney and living will. Now, just a quick step back in time. It used to be very often, many years ago, what we would do is a combination of financial power of attorney and healthcare power of attorney. And then we would have a standalone living will. And the living will says, essentially, if I'm in the very end stage of a terminal condition or permanently unconscious, I don't want extraordinary means used to keep me alive. Nowadays, as a result of some changes in the statute and just a change in practice, we typically have a standalone financial power of attorney and then a second standalone healthcare power of attorney living will. Excuse me. And this document deals just with medical matters, And it has two parts. The durable healthcare power of attorney, where I name somebody as a healthcare agent, and part two is the living will. Now, there's no set format for this. It's not mandated that a certain format be used. The Pennsylvania statute has a suggested format for healthcare power of attorney and living will. And I can tell you what my practice has been. That suggested format contains about 12 pages of information. I've compressed it a little bit to about half of that. And I have the language, the important language with regard to healthcare powers of attorney and living wills in that document. And so what I find is that doctors and medical facilities are familiar with that particular language. So that's what I utilize. So the healthcare power of attorney and living will, just a broad overview on this. I have a healthcare power of attorney and living will. Now, say if I left my office and I were to be in an accident and I'm taken to the hospital and I'm unconscious, somebody would have to decide what medical facility I would be placed into and what type of medical and surgical procedures would be utilized. My wife is my healthcare agent. Under Part 1, the durable healthcare power of attorney would make those decisions. But say if weeks down the line, a doctor says he's now permanently unconscious, he's in a permanent coma. That's when Part 2, the living will, kicks in, where I have said, while I was capable of expressing my wishes, if I'm in that condition, I don't want to have extraordinary means used to keep me alive. So, on the durable healthcare power of attorney, agent has authority to make any healthcare decision that the principal could have made. And if no durable healthcare power of attorney, then the person making those decisions is called a healthcare representative. And we put in here persons who may act if you don't have a healthcare power of attorney. And it kind of follows what is presumed to be people's intention, but it's not always this way. and, a spouse, and, and it just follows what may be presumed. But if you get to, say, number 2, and you have an adult child, well, here can be the issue. What if there's 2 or 3 or 4 adult children? And what if they all have totally different opinions? And then what do the doctors do? What do the facilities do? In those situations, it's good to address that right up front with the durable healthcare power of attorney and not leave it to chance as to who would have the ability to make those decisions. The living will. This becomes operative only when a copy is provided to the attending physician and you are incompetent and in an end-stage medical condition or permanently unconscious. So on this document, you have to be either in the very, very end stage of a terminal condition or permanently unconscious. And that's the key to remember, when is this effective? So in the example I gave, if I were in an accident and I'm taken to the hospital and I'm unconscious, I'm in a coma, but I'm not in a permanent coma, I'm going to receive every type of treatment that could be needed, anything that could be needed. It's only if I'm permanently unconscious with no chance of coming out of that. So the living will, if you would be in the condition described above, in other words, if you would be in the very end stage of a terminal condition, or if you would be in a permanent coma, this document reflects your wishes so that others may be relieved of the burden of making those decisions for you. And I think there's 2 benefits to a living will. One is, as stated there, in that living will, I have made my own wishes known while I was capable of expressing those wishes. That's a big thing, because if I'm unconscious, I can't say, doctor, don't hook me up to the machine. But the second reason is I want to relieve my family from the burden of making those decisions. And so there's, I think, 2 benefits to that. I can't tell you the number of times that clients will call in and they'll say, the number 1 document I want is that living will, because I don't want my children or other family members to have to make these very difficult decisions that I made. And so they really want a living will. Now, just a little more about that healthcare power of attorney and living will. I always, and there's, in that format that I use, there's certain things to be initial, to provide some greater clarity, for the family as to what your specific wishes are, and when, the power of attorney would be activated, and whether there's any type of leeway given to the agent in making decisions. It can all be put in there. But I always suggest that in addition to having those documents, or that document, the healthcare power of attorney and living will, that the client speak with the family and elaborate as to what their wishes are, and to let them know, in more detail what their wishes would be. The really difficult situations are when somebody, say, is in an accident or develops a medical condition where they cannot make decisions. And then all of a sudden, the family is wondering, what do I do? What do I do? With regard to those healthcare decisions, how do I handle it? And it's good to have that document in place. And it's very similar with regard to the financial power of attorney. When I do financial powers of attorney, just to back up on that a minute, after those documents are signed, the financial power of attorney, I say to a client, you should really do 3 things. 1, you should let whoever is known as agent know that you have that power of attorney, the financial power of attorney. Secondly, let them know how they're named as agent under the power of attorney. And thirdly, let them know where they can find the document if they need it. And it's the same idea with regard to the healthcare power of attorney and living will. I can't tell you the number of times that a family member will call in and they'll say, I know my parent has a financial or healthcare power of attorney, and I think I'm named as agent, but I have no idea where the document may be. And so it's always good after the documents are completed to let the agent know where the documents are. In fact, if a client says to me, after I sign this, I'm going to put this in the top drawer of this chest of drawers, I'll put a note to that effect. Now, it may not be the same later on, but at least we have a starting point as to where the document may be. So we move on to the role of an executor. So think of it this way. A client is acting as agent, say, for their parent, and the parent passes away. Well, that power of attorney is automatically revoked. The agent no longer has any authority as agent under that power of attorney. It's revoked. Then it's the authority as executor or administrator of the estate. Typically, there's a period of limbo where nobody has authority. Because again, if you think of it this way, the power of attorney is revoked by death. And until that will is probated, which is after the funeral, nobody has authority. So there's a period of very often of about a week where nobody has authority. And I'll say, any bills that come in should just be accumulated. Any checks that come in should be held. And then after the will is probated, then you'll be named the executor, and then everything can move forward. So what is an executor and what is an administrator? An executor is one named in the will. An administrator is one who's appointed where there is no executor named in the will or where somebody passes away without a will. Think of it this way. If I have a will that names a child as executor and that child predeceases, maybe I have another child as a successor executor. And it's always good, by the way, I think, to have successors whenever there's individuals. And say if both of them predeceased, well, the will would still be valid, but an administrator would need to be appointed, and that administrator would serve the same function as an executor. But the administrator, say, would not be named in the will. Now, what if somebody has no will? And that's typically not a good situation, because if somebody doesn't have a will, then all of their assets pass by the intestate statute to the intestate heirs. Every state has their own intestate statute that very mechanically provides where assets go. Sometimes they comport with the person's intent. A certain amount to the spouse, a certain amount to the children, or if there's no spouse, to the children, or no children to grandchildren, and so on and so on. But you leave it to chance if you don't have a will. So if there is no will, there, of course, is no person named as executor. So then an administrator would be appointed. And generally, that would be the one or ones who inherit the estate. So say if there's two children who are the intestate heirs, they would be the ones entitled to serve as administrators. Sometimes in those situations, say one of the children renounces their right to serve and says to the other child, you're in a better position to handle this than me, and then they serve. So pre-probate matters to be completed. When somebody calls in, they say, my family member just passed away, what do I do? Well, what I try to do is put their mind at ease and say, there's nothing that you need to do right now, because the power of attorney is no longer effective. It's not until the will is probated that anybody will have authority. And I say, you have enough on your minds just with the passing of the family member that you don't need to worry about things. But the things that they do want to be thinking about is to locate the original will, if there is one, and of course, to complete the funeral arrangements. And then oftentimes I'll talk to them about the number of death certificates to obtain, and that depends on the circumstances. And then I say, assemble the decedent's financial documents. In other words, the checkbook, any recent brokerage statement, any bills to be paid. Any financial documents are always helpful to assemble and get together. And so what's needed to actually probate the will? It's the original will, a death certificate, and a petition for probate. And the petition essentially says that the person passed away on such and such date, where that person passed away, where their last family or principal residence was, what the approximate size of the estate would be, because the Register of Wills has a charge based on the size of the estate, who the executor is named in the will, who the attorney is, and it's a request that the Register of Wills formally name and appoint the executor of the estate. Now, prior to last April, the typical process would be I would meet with the client in the office. I would go over all these documents and plus several others that would be needed in the administration of the estate. And we would walk about 2 blocks up the street to the Register of Wills. And we would go into the Register of Wills and show them the original will, original death certificate, and this petition. And the register would look at it and see everything's in order. You know, you're the executor named in the will and all the other documents are in place. And the Register of Wills gives the executor a note saying that the executor would be saying, I will well and truly administer the estate and abide by the laws of inheritance tax. Because when you serve as an executor, you are a fiduciary. You have to handle the assets of the estate even more carefully than you handle your own assets. So you're held to a high standard. And that oath, it's kind of like getting married, you know, it's a very solemn procedure. So after COVID, what happens? Well, as with so many things, the world has changed. And we have virtual probates as virtual webinars right now. And the way it works is I would get to the Register of Wills a copy of the signed will, a copy of the death certificate, a copy of the driver's license for the executor and the petition. And the executor would review everything and see everything is in order and then schedule a virtual probate. And then what would happen and does happen is the Register of Wills is in their office in the Judicial Center. I'm here. Sometimes the client is here, especially in recent months, or the client can be anywhere in the world. I've had some wills that were probated, one where the executor was in Chicago, another where the executor was in Boston. I mean, they can be anywhere in the country. And as long as everybody can see and hear each other, that's all that's needed. And then the Register of Wills will ask the executor to agree to the oath, and the executor will actually sign where the Register of Wills will be able to see them sign. So it's actually a very good procedure that I think will continue well into the future. So on the next page, what are the responsibilities then of the executor of the estate? Well, they have to collect the assets of the estate, make sure that they're secure, liquidate assets as necessary to pay bills and expenses, to pay all taxes and other claims due by the estate, and then ultimately to make distributions to the beneficiaries of the estate. That's very succinctly what the responsibilities are. There are a lot of details in between, but basically that's it. Some of the matters to be completed in the administration of the estate. On the next slide. Obtain a tax ID number for the estate. Very often we get a tax ID number for the estate, which is equivalent to our Social Security number. And if you think of it this way, during the administration of that's it. Thanks, Pat. The estate is an entity. It's like you and I, and it has to report income earned during the administration of the estate, just like we report income under our Social Security numbers, the estate would report income under the tax ID number for the estate. And so when we would open an estate checking account, we provide the bank with that tax ID number, like a Social Security number. So they report all income earned under that Social Security number. We advertise the estate. I don't know if any of you have ever taken notice of the notices in the newspaper with regard to estates. These are formal notices, and they have to be to be effective, in the local legal publication, which is the York Legal Record, and a publication of local circulation. Typically, we put it in the Dispatch and the Daily Record. And it's once a week for 3 successive weeks. And what those notices say, in brief, is that any debtor of the estate needs to come forward and any creditor of the estate needs to come forward. And if they don't do that, within 1 year of that advertising process, they're cut off. So it's really important for the protection of the executor so that they don't close out the estate, and then a year and a half later, they find out, a claimant comes in and they say they need to be paid. They're cut off. So it's really an important piece. Now, we have to send out notices of estate administration to the beneficiaries of the estate and to any spouse or child, even if they are not named in the will. So say this notice, by the way, needs to go out within 3 months of the probate of the will. In my view, it's a very cold, formal notice. It's 1 page. It says this person passed away on such and such date, who the executor is, who the attorney is, and that they may have an interest in the estate. I always accompany that with a letter, explaining a little bit of the process that's going to be followed so that the beneficiary has some idea as to what's going to happen. And again, that notice needs to be sent out within 3 months of the probate of the will. Now, say if a spouse or child is not named in the will, they need to get a notice also. So as an example, say if a child is disinherited, that child needs to be notified that that will was probated, and they need to get that notice. Request valuation of all estate assets. This is important because we need to file, we'll talk about that in a minute, a Pennsylvania inheritance tax return within 9 months of date of death. And we need to value all the assets on that exact date of death. So I send letters to the banks and brokers and so on. I correspond with the Department of Human Services to ascertain whether or not they assert any lien. This applies if somebody were over 55 years old, and if they received medical assistance, then there would be a lien that would need to be paid. Even if they did not receive medical assistance, I need to correspond with that office because we need to get a certification from them saying that they have no lien. You need that to be able to sell real estate, as an example, that certification. I always correspond with the Department of Unclaimed Property. It's surprising the number of times that people have had property escheat to the state of Pennsylvania and never even knew about it. It could be an old bank account, it could be an insurance policy, it could be, dividends, and any number of things. But I would guess, probably a quarter of the estates, that I handle, there is something up there that we end up collecting. On the next page, pay the inheritance tax due. Now, Pennsylvania only has a few tax rates. Anything that is paid to a spouse, 0 tax. And anything that goes to charity, 0%. So if you have a bequest in the will to hospice, that is 0 tax, or any other 501c3 charity, 0 tax. And same with the spouse. Anything that goes to a lineal descendant or to a parent or grandparent, the tax rate is 4.5%. Anything that passes to a sibling, brother or sister, the rate is 12%. And anything to any other individual, the inheritance tax rate is 15%. So in other words, Anything that would go to a nephew, niece, cousin, friend, aunt, uncle, 15%. The Pennsylvania inheritance tax return needs to be filed and all tax paid within 9 months of date of death. Any inheritance tax paid within 3 months of date of death is eligible for a 5% discount. I always try to take advantage of that by paying roughly, it could be anywhere between 90 and 100% of the tax. Usually it's about 95%, because as an example, if there's real estate involved, maybe we haven't sold the real estate as yet. We don't know the value of the real estate or any expenses on the sale of the real estate. But I always try to pay the bulk of that within the 3 months. And then we have to obtain approval of the Pennsylvania inheritance tax return. Unlike our individual income tax returns, where we file those returns and you never hear anything, on the Pennsylvania inheritance tax return, the Department of Revenue reviews 100% of the returns that are filed. And then we get a response. Either it's accepted as filed, or they disagree with the valuation of an asset, a deduction, or something like that. Now, very interesting, before COVID and probably up until last summer, the Department of Revenue was taking 6 or 7 months to review these inheritance tax returns. Amazingly, now, as of the last several months, they're getting the reviews completed in 2 or 3 months. Hard to explain. Federal state taxes beyond the realm of most anybody now, because everyone has an $11,700,000 exemption from that tax. Disposition of real estate and personal property. That's something that, of course, has to be addressed in the administration of the estate. And there's various ways to sell the real estate and personal property. On the next page, we need to complete and file the final individual income tax returns and fiduciary income tax returns. Very briefly, say if somebody passed away on March 1 of this year, final individual income tax returns would be filed for the period January 1 of 2021 through the end of February of 2021. And then fiduciary income tax returns, reporting income to the estate with that tax ID number we were talking about, would be from March 1 until we close the estate. And the tax year for an estate would be on a fiduciary tax fiscal year, and it could end anywhere up to 1 year from date of death, has to end the end of a month. So it could go all the way up to February 28th of 2022. We need to complete and file with the Register of Wills an inventory for the estate that will list all the assets in the estate and show the values of the assets as of date of death. We complete a first and final account as to the executor's administration of the estate. And I prepare a first and final account that accounts for every penny in the estate. It shows all the assets that came into the estate. It shows all gains or losses on liquidation of any asset. It shows all income earned in the estate, interest, dividends, all expenses paid. And then ultimately, what goes to the beneficiaries of the estate. And there's different ways to close out the estate. You can close the estate by an agreement of the beneficiaries or by filing the account with the court. So say if I have an estate and I have 4 children, and one of those children is the executor of the estate. Well, what we can do is close out the estate by an agreement whereby, say, the other 3 children acknowledge receiving a copy of the one child's account as executor, agree with the figures contained in there, waives the need to file the account with the court, releases the executor, and indemnifies the executor in case a bill came in after everything was distributed. I think the majority of estates are closed by an agreement. But say if you may wonder, well, why would I file the account with the court? It could be any number of reasons. An example would be, say if one of those 4 children said, I don't like, executor, how you handled the estate. Okay, well, we'll file the account with the court. We'll notify you as to the filing of the account, and then you can file objections to the account. Or another example would be, say if there's a creditor lingering out there and they say, I'm owed this money, and we think, you're not owed this money. We don't think it's a valid debt. We'd file the account with the court, notify the creditor, and they could go into court and prove their claim. So that's how an estate would be closed. And then ultimately, we would file a status report with the court saying that the estate is closed. Everything is finished. Non-probate assets. This is important, really important, because these are assets that would not pass in accordance with the will. Individual retirement accounts and other retirement accounts. The will means nothing as to that. The beneficiary designation form controls how those assets pass. And so they're very important because, very briefly, if you think of it this way, if I have money in an IRA, and I have my spouse named as a beneficiary, spouse is the only one who can roll that over into his or her own name. And then say if I have my children as alternate beneficiaries, then they could take it and they would have a period of 10 years to take that money out. But the point is that those assets do not pass in accordance with the will. They go by the beneficiary designation form. And then just another note on IRA assets. Very often, they are the ideal vehicle to make charitable gifts. So say if you wanted to have a bequest to hospice and community care, a good way to do that would be through your IRA. Because if you think of it, the charity doesn't pay any income tax. If that same asset went to, say, children, they're going to pay federal income tax on that. And so instead of having the gift through the will, and then having the IRA or a portion of the IRA going to the individuals, if you just reverse it, it's a great way to make charitable gifts. And then also, just a quick side note, if somebody is over 70 and a half, there's the ability to give up to $100,000 a year to charity by a direct transfer from the provider to the charity. So if you wanted to make a gift to hospice, you could do that up, and you're over 70 and a half, you can do it up to $100,000. Payable on death accounts and transfer on death accounts, they're very similar. In other words, where an account says this money is payable on death to a named beneficiary. You always want to coordinate that, though, with your will, because it can distort a will. If you say, that brokerage account goes to, a child, well, how does that affect other beneficiaries in the will? And who pays the inheritance tax on that? Life insurance passes to the named beneficiary. Jointly owned assets are going to go to the surviving joint owner. And very often husband and wife, very typically, they'll have assets owned jointly as husband and wife. And it means that upon the passing of one, they go automatically to the survivor. Sometimes, people will set up an example would be a bank account joint with a child. And something that people don't realize, if they do that, upon the passing, say, of the parent, that account's going to go automatically to the child. But what happens if the child predeceases the parent? Then the parent has to pay inheritance tax to get their own money back. So it's just something to be careful about. Assets in trust that pass to beneficiaries other than the estate. And I've read a lot of trust agreements. So say somebody has assets in that trust, and they provide in the trust agreement, upon my passing, those assets go to family members. They're going to go directly to the family members, and they won't go in accordance with the will. So the non-probate assets are something to really, really be aware of, and be aware of how they pass. I find nowadays, oftentimes people have a large portion of their wealth in retirement funds. And those retirement funds go in accordance with the beneficiary designation form and not the will. And so it's really, really important to make sure that they're correctly designated. Actually, what I very often what I do is I'll ask a client to get a blank beneficiary designation form and get it to me. And very often I'll prepare that form for them. An example why it could be beneficial is, what if in that beneficiary designation form, a lot of times the forms that are provided by institutions don't adequately address what happens if a beneficiary were to predecease, or what happens if that beneficiary would be a minor. Who's going to hold that for the minor? So I try to address those issues in that beneficiary designation form. So I've been a little bit long-winded, and any questions by anybody?
Yes, Tom, there are a couple questions. And, the example that you kind of walked us through, it seemed like the person who had named the executor had an attorney. And so then the executor came to you as the attorney to kind of help them through this. So one of the questions what if there is no attorney? Does the executor then need to find one?
Exactly. And, the attorney who prepared the will is very often a good person to go to, because they would probably be familiar with the affairs of the decedent. But there's no requirement. There's no requirement that the executor go to any one attorney. They can go to whoever they want. So, if I prepared the will, I may have knowledge, of the circumstances and the background and information with regard to the estate plan. But the executor is not required to go to me. But I think generally it's a good idea, to have an attorney guide you through the process.
The next question is, what is involved in the executor deciding not to accept the job and someone else assuming the job of executor, as in one sibling refusing despite being named in the will and another sibling taking over the job?
It's a great question. And it's not unusual to have, say, the primary executor renounce the right to serve. And the process, very frankly, is very easy. The renunciation is basically one short paragraph, a couple of sentences saying, I was named as executor in the will, and I renounced my right to serve in favor of the successor executor. And it happens every now and then. It could happen, say, if two children are named executors, and one of them lives out in California and the other is here in York. The one in California would say, I could serve, but it would be easier if you were to serve, and they would renounce. And the other situation could be if the one in California was, say, the primary one, and then the one here in York is the successor. Same idea. And incidentally, again, I always want to have a successor, as executor, if that primary person is unable to serve. And the same idea as far as an agent under a power of attorney. I always like to have a backup. But it's an easy thing to renounce. Easy.
Terrific. The next question, if very limited assets, no real estate, no vehicles, minimal balances in banks, etc., do we still need to file with the Register of Wills and complete all the actions you listed on slide 29 and 30?
That's another excellent question. There are simplified procedures on very small estates where you don't have to probate the will. A quick example, if the total standing in any one bank would be less than $10,000. You don't need to probate the will. And the statute says it gives an order of priority who can do this. You know, it can be a spouse, and if no spouse, a child, and then it goes on, you know, to a couple different family members. An example would be, and I'm doing this right now, client's parent passed away just recently, and the only asset is a bank account with about $9,000 in it. And I said, Joe, we don't need to probate the will. We don't need to go through that process. All you need to do is present a receipt of funeral bill and take a death certificate along to the bank, and they will pay that money out to you. And then you need to see to the proper application of those funds. So that's an example of a simplified way in which it can be closed. Another thing that sometimes turns up is, say there's a car titled in the decedent's name alone. Well, you know, there's simplified ways in which that can be transferred over to a spouse or a child through, typically it's a place like 3As. So there are ways.
All right, great. And the next question, I filed the paperwork in Lancaster County on February 8th to probate a will, and I am still waiting for my short certificate. It is now 3 months after the individual's death. Did I lose my ability to get the 5% discount?
Well, the discount is within 3 months of date of death. So if it's beyond that, you know, that would be, you know, it sounds like you would be beyond that time frame. It's surprising that, wow, you know, the will was probated in February and no short certificate as yet. So
another question, are the procedures any different to probate an insolvent estate?
Another great question. It's the same basic process. I will say that there are situations where there are insolvent estates, and I'll say to the executor, you know, I'm not sure if I would even probate the will. You know, if there's a few $1,000s in the estate, and these things happen, and there's you know tens of thousands of credit card debt or other debt. Sometimes, you know, it's better just not to probate the will and allow a creditor would be able to open up an estate and proceed with the administration of the estate. The procedure, if you have an insolvent estate, and you know these come up now and then, there's an order of priority as to who gets paid. So it would be, first of all, administration expenses, any executor's fee, any court costs, attorney's fees, any other cost would be paid. And then you have, you know, basically medical expenses incurred within 6 months of date of death is in the same category as funeral expenses. And then you get to general creditors. The point is, there's an order of priority, but it's the same basic process.
Thank you. If no successor trustee is named in will, can the named executor still renounce right to serve and ask that someone else, like a sibling, assume the successor job?
Well, that's a good question. It's one that's a little bit down in the weeds, but I'll try to answer this. First of all, it would not be a trustee is different from an executor. An executor is the one who administers the estate. So say if the primary executor says, I can't do it, and the successor says, I can't do it, then you really get down to the residuary beneficiaries of the estate, and they're entitled to serve. So say if there's 3 children, and one child is named executor, second child is named successor executor, and they both renounce the right to serve. But the residue of the estate goes to the 3 children. So it would be that third child who gets the residue of the estate that would be entitled to serve. The statute has a mechanism to provide who would be named.
All right, that's the last of the questions. We did have one comment pointing out that Social Security does not recognize power of attorney. They have or use a separate process called representative payee.
Yeah. 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 Social Security create their own rules.
Yeah. Yes. Well, thank you, Tom, so much for all of this knowledge that you've shared with us this past hour. We will be sending Tom's presentation and contact information out to all of the attendees in case that you have any questions. Feel free to reach out to him. Thank you so much, and I hope that you will join us for our future seminars coming up in the next few days. Have a wonderful day, everyone.
It was my pleasure, everybody. Thank you.